Hi, my name is Demi, and I am the chair of the Forms Committee. And on the side is Stephanie, and she's our co-chair. And then we have Nick, who's also on the Forms Committee. And we want to go over the changes that we have made this year so that you guys understand some of the changes that we're going through.
So in addition to being the co-chair, I am actually not a property manager. So I'm here today to ask those questions with these two amazing property managers that maybe agents don't understand or aren't as familiar with. So this is really just like an outsider's perspective, and they have the answers.
We're going to start out with the residential purchase agreement. Can you lead us through some of that?
I can. So the first change we made was the very first page, right?
Yep.
We updated the earnest money deposit. We cleaned it up a little bit. We made it easier to read.
Yeah, before it was a little confusing the way it was worded, because we added a section just a few years ago just to accommodate the wire transfers. So this just cleans it up a little bit. You can check off it's a check or wire transfer. There's a default for one day that you're going to deposit a check, or you can type in a couple days for a check. And then the rest of it remains the same. So it flows a little bit better.
Easy peasy.
Yeah.
So we had to update our closing fees to stay compliant with the settlement. I think it was pushed out a little bit fast. Obviously, we needed forms. We changed this to remove the commissions from the closing fees, as it's a separate part in the purchase agreement. I believe that is how we did that,
what
correct?
we did, yep.
Okay.
The other changes, though, that we did in this section removed things that were misleading regarding the buyer's loan and the seller having to pay some costs on behalf of the loan. So this just creates a general section that the seller can contribute towards closing costs on behalf of the buyer as well.
But not towards closing agent fees.
That was the part that was removed, right, because of the settlement. So we had to remove that.
Absolutely.
Okay. We also removed, this one's it's barely noticeable, but the word federal on our fair housing. And this was because I believe Nevada fair housing laws were higher than the standard federal. So we covered both by doing so.
Yeah, it was a little misleading the last time because when it says federal, it assumes that there are some federal protections in this paragraph that are not. So by removing federal, it's a little bit more accurate. Plus, it matches the listing agreement.
And we like to make our forms consistent across all of them. We've been trying to fix those
that
as
and
much
less
as possible.
pages.
Right.
We were trying.
Easy to read, easy to understand.
Right.
Yeah.
Right.
And then we added a big one, I think that's pretty important.
Yep.
Time is of the essence definition.
And why? Tell us why it's really important.
Because time is of the essence.
People have to understand that when they put in dates like due diligence or loan contingencies, etc., that those are solid dates that we need to follow and adhere to. And they're not something that we can just let float during the contract. They're meant to protect our clients. And so we need to make sure that we, as agents, keep track of that stuff.
Yeah. I think it was kind of looked over in the beginning, and adding this in there really gives a definitive deadline.
Correct.
It does create the definition, so everybody knows this is the punctual performance section for everybody.
And it is important to follow. I know some of it goes wayside sometimes.
Then the next form that we changed, and this was a lot of big changes due to the recent legislature, and then we cleaned up quite a bit of the form itself, was the residential lease agreement, along with the owner-managed lease agreement. The changes were made on both the documents at the same time to reflect the recent laws and updates. Nick, do you want to cover some of this stuff?
Let's talk about the residential lease agreement first, and then the changes that we made in this residential lease agreement are mirrored in the owner-managed lease agreement.
Correct, because they both have to reflect the changes that we made so that the owner is aware as well.
Right. So you'll notice on page 1, section 3, the AB 121 made some things that are very specific requirements on the residential lease agreement. So the section, the term is changed to include the fixed periodic fees, which are included in the section down below, item number 4.
And how do we calculate that?
Section 4, the new regulations require that the lease fee be disclosed in one payment, and that one payment must include all of the mandatory charges
That are fixed, correct?
are fixed and part of what the tenant has to pay.
Okay, so I have a question. The periodic fee, is that just the monthly or is that for the entire lease term?
So the periodic fee here, as disclosed, is a monthly fee.
If someone was just to look at it and not quite understand, or new property manager, something like that. This is just all of the things I have to pay for that month and a total at the bottom.
A total at the bottom for that.
For
and
that.
then on the term, you would take that total figure times the length of the term, whether it was a 3, 6, 12-month term, whatever that was, so that they know for that lease agreement, that total period of time, that they would be out $10,000, $12,000, whatever the figure is.
So as we're disclosing this is the required monthly fee. So you're going to break it down every month what the tenant's going to pay.
Right.
So you'll start with the base rent, and then you'll add in trash or sewer if it applies, and then anything else that the tenant is expected to pay monthly that's part of that total rent amount. We have to itemize that on here.
Not only that, though, when we get into like the pool service or landscape service, if that applies, we also have to disclose whether it's a weekly service, monthly service, or whatever it is, so that the tenants are fully aware. We have to make everything very transparent. And then if there's any additional fees that are particular brokerage charges, whether it's an admin fee, a tech fee, or whatever, we've allowed for that by leaving the other space there. But what has to happen is you have to define it, and then you define it in the mandatory addendum number 1 that comes on the back. You have to actually state what that fee is for so that the tenant understands.
And on the last section that we added here, still on number 4, this service period covered, is what you would select if you were adding additional charges in the other section, to let the tenant know if there's additional service charge, the period that the service covers, if it's monthly, weekly,
Correct.
bi-monthly, bi-weekly.
But in the number under the monthly fee amount, if it is a weekly fee or something like that, you still have to put the monthly amount in there, just so that you're able to come up with that total fixed periodic rent on a monthly basis. So it's kind of a little bit confusing because you're describing whether it's a weekly service or bi-weekly, but the fee itself is for the monthly fee. Now, Nick, can you go over the utility portion and what's changed in this?
Sure. So we talked about disclosing the one rent amount. Okay, you cannot change. However, there's a carve out in the regulation that says that if the utilities cannot be placed in the tenant's name and will remain in the owner's name, that charge can be separate from this periodic rent and charged separately. And so,
As a variable fee, for instance.
because it would be variable if it's a utility charge that the tenant cannot put in their name.
So would this be in, for instance, in a, maybe like a condominium?
If you were in, say, a high rise and they had metered water, then that was broken up into the different units, then that's the portion that may vary
Okay.
that you can charge as a variable charge each month, but you do have to provide the tenants with a copy of the bill.
Okay.
And explain it outright that way. But what's really important is that the understanding has to be that if the tenant can place the bill in their name, even if the owner wants to keep it in theirs, they can't. So the tenant has to and is responsible in putting that utility in their name.
Yeah, the two carve-outs are for public utilities and for master metered. You have to disclose that. So
Correct.
there's 2 different sections that we added. So under the public utility service section, you would disclose that.
But that only really applies for electric, gas, and water, correct?
Right, that's right.
Okay.
Just those 3. But you have to add, if it does apply, you'll need to disclose who the provider is and the phone number as
Correct.
part of the disclosure. And then part of it is you'll have to supply the monthly invoice to the tenant as well.
Correct.
Yeah.
So maybe you guys can explain it a little more, just so I understand, as again, coming from someone who doesn't really work with these forms as much. In the instance of like maybe trash and sewer, those are more also owners, but quarterly or not monthly fees. So how does that work?
Well, traditionally what we've done is, say, for instance, we charge like, say, $45 a month for trash and sewer, right? Because maybe those are quarterly bills that come in. So we prorate it. And sometimes like in the beginning of the year, it's a little bit less. At the end of the year, it's a little bit more. It evens out. With this bill, we can't do that anymore. We really have to charge based on what the current bill is and err on the side of the low side. And then when the renewal comes in, then we make whatever adjustments need to be there. Because what they don't want, even $1 more, is what the legislators are not wanting us to charge. So it has to be actual.
So any
bill.
extra fees that would just kind of sit there.
Yeah, they don't want extra fees. So if it's $43.57, you divide it by 3, and that's what you charge for that, instead of trying to round it out. Because we as property managers, of course, always love round numbers, right? We hate these 37 cents and all that other stuff. But in this particular instance, it's best to do the exact number.
Don't round it.
Yeah, no rounding.
Got to be exact.
You got to be exact. So we're going to have funky numbers.
So as a tenant, let's play tenant's advocate here. I sign it. You as a landlord get the sewer bill and it goes up. That does not affect me.
No, not at all.
One thing that's important to know is that the new law that went into effect, it's a consumer protection law for tenants. And whatever is placed on this lease agreement for the periodic rent fee, it's fixed for the whole term.
Okay.
These items cannot change. So if you're going to calculate, like say in your example, the sewer, you're going to take the quarterly amount and divide it by 3 and come up with a monthly amount, that's going to be remain for the term, right?
Okay.
And that cannot change. But another example, you bring up an interesting point, is that, we're required to disclose the monthly fee, right? And so like, say, for example, you'll have landscaping, if landscaping is included, right? But the landscapers, you'll pay a flat amount every month, but they may not come out every month because the weather, you may not need them every month, but the tenant is contributing every single month to that fee. So off to the side, you would notify and let the tenant know if that monthly service fee covers the monthly. It's a monthly service fee, right?
It's really a yearly fee divided by 12.
That's right.
Okay, that's the best way to explain it.
As long as it's a 12-month lease, though, correct?
Correct. But
Okay.
normally the way landscapers work, for instance, is during the hotter months when there's a lot of weeds and there's a lot of that kind of stuff, they come out there on a weekly basis. And then during the cooler months when there isn't as much need, then they go out on either a bi-weekly or a monthly basis, depending on what the need is there. They're not just going to come out to look and not do anything, right? Because that's not a good use of their
Hope
time. Right. But I'm just saying the way we get charged for that service is spread out over the year. Okay. And then divided back into a monthly fee. So the service may not always be consistent. It's not weekly every single 52 weeks out of the year, but it varies, but the fee is steady. Okay.
And then for like the variable water bill, then that would be in per se the tenant's name because that fluctuates and the owner doesn't have control over that.
Nowadays, if a property manager or an owner have the water bill in their name, and customarily what we did before is we charged it because the owner would ultimately be responsible for it. Now we can't do that. So the tenant has to put it in their name unless there's some reason why they can't. Okay. And then if the property manager has to kind of keep an eye on those to make sure those bills are paid so that when that tenant moves out, the owner doesn't have a huge bill that they need to pay. And that's part of what we're going to be responsible for now, that this bill takes away from the way we normally have done business. Does that make sense?
Yes, it does.
Perfect.
So that is just the monthly fee. So let's deep dive into now move-in is separate from those fees, correct?
Correct. So basically, the changes that we made on the move-in is really changing the terminology to reflect that fixed periodic rent that we're talking about. So if you're going to have a prorated rent, because not all tenants move in the beginning of the month, right? Instead of it being rent, just saying rent, we're now saying that it's a prorated fixed periodic rent. And that's what goes on the top there. Then we added a section that's next month's fixed periodic rent, so that a lot of property managers, for instance, say you have a tenant that moves in on the 18th of the month or the 23rd of the month. They want that prorated part, but they also want the next month's full rent. So we added that on there. And then also, because different property managers have different fees, we left a whole bunch of others so that they could fill in whatever their requirements are, so that that would be covered for their move-in costs as well. Okay. Does that make sense?
That does, yeah.
Okay, cool.
So it's a no-brainer for someone looking at it. I can just see this is what I have to pay right out of the gate.
Yeah, before I move in, here's all the total costs. And then the no-brainer too, this is what my fixed monthly cost is. So that way I can budget accordingly.
This law is very serious. When this says the total fixed periodic rent, it cannot change. It simply cannot change during the term.
Yep. So if you get a bill midterm, the owner's going to have to be responsible for it regardless until the new lease term comes up.
Okay.
The other thing I wanted to mention, since we're on this page right after the move-in fees, is that the other part of this new law that went into effect, mentioned that the tenant has to have a free form of paying the rent.
Correct. Oh, yeah.
So part of the regulation also says that if we use a portal, an online portal, and the tenant has access to that portal and there's a fee charged, like a convenience fee charged, we have to disclose that fee on the lease. So the lease must say that there is a convenience fee charged for using the portal and the fee is X amount of dollars. All that we really need to do is just disclose to the tenant that, hey, you're going to use this portal to pay your rent, and the portal is going to charge you a fee of $2.99, whatever that fee is. You just have to disclose it somewhere in the lease.
So we can put it under additional terms at the back.
Put it in the back under Section 7, additional fees.
If you use your portal, you would be charged X amount of fees every month, as long as it's just
Yeah, and most property managers will use the same lease template, and you can probably just hard code it in your template under additional fees or something.
And the other thing that's really important is the law doesn't allow us to upcharge anything on that fee. So if the portal charges you $2.99, you can't charge $3.50. It has to be the exact amount, whatever that may be.
Okay.
Okay.
All right.
Yeah.
I noticed that we changed occupants. This was to add minor occupants versus adults. And was there a specific reason for this?
Yeah. So the regulation did mention that you can't charge a fee to run a background check on minors. And
people were doing that?
People were doing that.
Apparently so. So the regulation made it very specific. And then we added it to the lease to identify, hey, who are the minors that are on the property?
So if you've got 5 applicants and you had 5 occupants and 3 of them were minor, then there's a problem, right? Because then you're collecting for the 3 minors an application fee, which is not allowed.
Okay.
So this is a little bit clearer. And also the other reason that it's good that it's on the lease, in case of an emergency, you always want to know what the occupants, there's 2 adults, 3 kids, whatever. So you can tell emergency situations, right? So that was another good reason.
Okay.
So under Section 14, we did add some things for occupants.
And this is where you would disclose the minors in that section, or adults versus minors?
Correct. The space was always for the total number of occupants, and you would put 6 in there, right? And you still do the same, and you list the adults in one section and then all the minors in a different section. So we added, whereas before you just listed the adults usually, but now we're adding we added a section to comply with the law that lists the minors as well.
So they're in the total persons, but then a breakdown separate just for there. Like you said, there might be 6, but 4 are minors.
Yeah.
So that way there's clear and concise. You don't have any questions.
It identifies the minors.
Okay.
Yeah.
Moving along, this was a lot done in this form.
We made a lot of changes in this form to comply with the law.
Yeah, there were a lot of changes.
The next one I see here is the utilities. So tenant responsibilities, I believe this was always kind of in the form previously of what the tenant was responsible for and what they weren't. So I guess explain this one a little bit more, maybe.
This was slightly modified to
Okay.
include the new exception to the periodic adjustment for the utilities. So this section just says that the tenant's responsible to immediately connect the utilities that they are able to put in their name. And Section A identifies that if the tenant's unable to put the utilities in their name, then this is what the landlord's going to be responsible for. So it just clarifies, and it makes the landlord responsible for connecting either the public utility or if it's master metered. Right?
So this is a little more clear
Yeah.
for both parties. There's no
Correct.
questions about
Yeah. This
who's doing
section
what.
obligates the tenant under one circumstance, and then it obligates the landlord under another. Page 1 discloses the fees. This section obligates
this
them.
is what you're doing.
Yeah.
So you have to have water as a tenant under this
Yeah.
checkbox.
Correct.
Okay.
Yeah.
And then we also added a section that if there was a variable amount, like a metered water or something like that, that you have to provide them with a copy of the bill.
Oh, okay.
It's specifically
Stated in there?
It's stated in the contract now.
Perfect.
That
Again, no questions. It makes it very transparent.
correct.
Yeah.
Full disclosure. That's what this bill is all
Okay.
about.
Yeah, it's intended to be that way.
Correct.
So then I see we also updated the animal section. Demi, would you like to elaborate? Why do we need to change our animal section in this whole form?
Well, before we just had a section that if you had an animal or you brought in an animal that wasn't approved, you would have a fine. And this is what a deposit was for the animal that you had. And it left it at that. There was no other information in there. So normally when a tenant comes in, okay, and if they have an animal, they would fill out a pet application. And the pet application showed approval, not approval. And then it wasn't shown anywhere again. So if you were looking to see if a tenant had a pet that was approved, you'd be searching through your application stuff, which most property managers, once a tenant is in place, really relies on the contract to look at the terms if they're looking for, any changes or whatever. So we took that aspect of it and put it in the contract.
Under 19A, the landlord has not approved any pets to be in the property, or the landlord has approved the following pets, and it's now specific to the type, the breed, the name, and the weight to accommodate, if the landlord does approve a single pet, it identifies that pet.
And the reason we did that is because a lot of HOAs, et cetera, will have weight restrictions. And we also don't want tenants to just assume, well, and this is a little bit morbid, where you had a pet that maybe died. And since I was approved on this pet, I'll just go get another pet. But we want to be notified when there's any pet changes. And the main reason, again, is to comply with either the landlord's request or the HOA's request or whatever is there. So we are notified.
So I see we made a change here on 19C also.
Yeah, 19C is an addition. We added and just combined service and emotional support animals into one section.
And I think the way we put this in there, it says such requests will be evaluated in accordance with all applicable laws, because it depends on whether it's a service animal or an emotional support.
The section just says that they will provide documentation that'll be evaluated by the landlord.
And again, there was no place. We have a separate addendum which identifies the service animal, the emotional animal, and that's okay. But we wanted to bring it back into the contract that says that they were approved, they weren't approved, so that everything is there. Plus, we're also making it clear to the tenant that we are not going to accept a website that they go on and pay $25 that says, oh, you're entitled to this emotional support animal. It has to be a legitimate request. Okay. But this just kind of tells them we're going to be looking to ensure that it is. And these are the animals or pets that have been approved for this property. And then the other thing we did just for property managers to be aware, we left a couple of blank lines underneath so that if you are approving more than the 2 pets, you have some room to put those in. But we didn't want to put it on the generic lease so that we weren't saying to a tenant, hey, you can bring 4 or 6 animals or however many, right? We left you some space so that you wouldn't have to try to cram it all in there.
So I noticed we have the maintenance and inventory listing updates. What is this? Explain to me, please.
Yeah.
Like I'm a toddler.
We added under the home warranty deductible section, the words for non-habitable items only. So
that way there's no confusion.
And I guess could you explain like non-habitable items?
in other words, if there's a maintenance call for something like the electrical, the plumbing or heating or hot water, that cannot be charged to the tenant.
Okay.
But other things that are considered non-habitable
So like
can
if
be.
my AC goes out in the middle of summer and it's 120 degrees in the house.
You can't charge the tenant for that deductible if there's a home warranty in place.
Perfect.
But something like appliances or landscaping or anything else that's non-habitable can be charged to the tenant.
Yeah, but home warranties don't cover landscaping.
I know. Good luck.
Good luck. Okay, so then replacement of locks. I noticed we changed something with that, and I guess I'm not sure what that means on replacing locks.
So the problem we have a lot is a lot of times a tenant will change the locks sometime during the tenancy. And the way we find out about it is when they move out and we don't have access to it. But that violates the contract. So we wanted to make it very clear that if they were going to change the locks, we would need a copy of that within however many
business days.
Like business days, however many you wanted to put in there, whether it was 2 or 3 or whatever was good for your, that you wanted. And then that way it's actually understood in the terms. There wasn't an ambiguous, oh, well, as long as you gave it to us on the day before move out, you still followed the terms, right? Because you gave it to us. But that's not true. The intent was always, when you change the locks, you give us a copy of it.
And that's just for, I guess, if you need to access the property in such case of an emergency or
inspections or anything like that. We're supposed to give them a 24-hour notice unless it's an emergency. And if we can't get in there, then usually what we have is a locksmith that's there and we end up changing the locks. It just becomes a very arduous process to get the new keys and all that other stuff. And that's not right to change it out. But a simple solution would just be to get a copy of their keys.
This section was always there where they could change the keys and just provide it to the landlord, but it never said when. So we just added that within blank days.
So just to clarify.
Just a small update. But again, transparency, disclose, makes it easier for both parties.
Yeah.
Correct.
We did speak about the addendums. This is, I guess, the last part of this change on the form is the addendums attached. I believe 1 and 2 are now required.
Yeah, this section 45 under A and B, these addendums are hard-coded in the forms. You don't have a choice. They're automatically included and attached to this lease.
And we already talked about addendum number 1. That was the definition of the total fixed rent. So you have to define what each section is. So you do that on addendum number 1. On addendum number 2 is the tenant's notice of disclosures. Okay. And basically what we did, we took out a couple of the disclosures that were in the actual contract itself and moved it to the notice of disclosures. Like we took out
It's just all disclosure.
military provisions. We took out the foreclosure disclosure and moved it to the disclosure, as well as the risk assessment of lead-based paint. In addition to that, though, we added some statutory requirements. We added the section on nuisance reporting and how they could do that. And then also the displays on rental properties. Even though the flag and the political signs were always in the contract, we added in the religious or cultural items that were also part of AB 121. So this way, everybody's on the same page and understands. So that's why this becomes a mandatory disclosure to the lease agreement. So that's both to the regular lease agreement as well as the owner-managed agreement. Both of those addendums will be hardwired in to both of those.
And I noticed we added the word pamphlet at the end of lead-based paint disclosure. So what does that mean?
So that includes both.
It includes both. We were always supposed to include both, but we just had the disclosure on there. And so we just cleaned it up a
So
little
is that if it's a yes, you get the pamphlet also?
Correct.
That's right.
Correct.
Okay. So we're moving on to the residential property management agreement now. Page 1 again, we're updating all the things. And what did we change on this form?
So section 2 was added. Just the section where it talks about the calculation for compensation, whether it's going to be based on the base rent or the total periodic rent.
Correct. We're giving the brokerages an opportunity based on business practice on which rate they want to charge off of. So in the past, we've always charged it off of rent. So we needed to keep the base rent in there. But there are going to be some brokerages that may want to charge their percentage off of the total fixed periodic rent.
So this is
It's the landlord to the broker.
landlord to
Landlord
the broker.
pays the broker
Oh,
in this
okay.
instance.
It's the owner-broker
Okay,
agreement.
so this is something that agents wouldn't see. This is broker, landlord,
Property manager,
Property manager.
to the landlord.
the owner of the house.
Of the owner of the property. Correct.
Okay.
Yeah, so
Okay.
this is the owner's agreement to contract with the broker to manage their property.
Okay.
And so section 2 deals with how the broker is going to be compensated. And so there's the option of either collecting based on the base rent or the total periodic rent. Whatever
Okay.
their business practice is, it allows them to just select
Pick
it.
one.
Yeah.
Correct.
Okay.
Whatever works best for them.
Okay.
Okay.
Next, we have this is the notice to the owner regarding tenant legal action. And I think this one was a huge change.
So this section, starting with 11B,
Right.
is a disclosure to the owner informing them that a tenant can make a claim against the owner if the owner fails to comply with the statutes. And so this section discusses noncompliance. There's a penalty potentially of $250 for deceptive violations. So this notifies the owner that if they fail to do something that the statute expects of them, there is a repercussion so the tenant can make claims.
But it's not just the $250. That's just if there's any deceptive actions. This is also allows the tenant to file against an owner if there's any habitability issues.
That's right.
correct?
So if an owner fails to correct any repairs that are requested, there's also, this informs the owner that the tenant has rights as well.
Correct. So this is a big change.
This is a big change.
And this is affecting, I'm guessing, mostly landlords, not so much tenants.
It's the tenant's right against the landlord's failure to perform.
Okay.
Yeah.
So they have a legal recourse if something goes awry.
Correct.
It really compels the owner to follow the law.
So there's no cutting quarters for
Right.
the owner.
Yeah.
And this is spelled out then.
It puts them on notice that, hey, if you don't follow the law, then there are repercussions that a tenant has against you. And so this informs them of that.
And then in addition, following along with that same law section, any property over 2 units, basically a tenant can take the owner to court if they're not making the repairs, not the repairs that a tenant has caused, okay, but actual repairs that are needed to make the property safe and everything working correctly. If the tenant takes them to court and the owner has not fixed those items, the court actually has a system in place now that they can put the property in receivership, make those repairs. The owner won't have a say, but he will be responsible for all the repairs. He will also be responsible in relocating a tenant to a different property while these repairs are being made, in addition to notifying them that they can't have any repercussions on that tenant for turning him in too. So you can't say it takes 3 months to fix the repairs. and that owner is responsible for 120 days worth of placement, and then the tenant is supposed to come back, well, then the owner can't take it out on that tenant after that.
So the
either.
tenant's allowed to come back after with no recourse from the owner.
Correct. So this is just, we wanted to make the owners aware that this was there for them to make sure that they take care of their property. And then the property manager's role during that time, it doesn't stop just because it's in a receivership. They still have to keep track of the property, keep track of the repairs, communicate with all parties, and do all of that stuff. So that's a big change.
The next one I noticed is, so this probably touches base on the lease agreement. So now we're coming back around and the owners for utilities and services. So that was also updated to be in compliance with everything.
So section 12 just makes the tenant aware that the owner is responsible for arranging and paying the utilities that they're subject to paying, right? And if that's not in the tenant's name.
Okay, so it just kind of goes back to the same lease agreement for the tenant side.
The lease agreement made the tenant aware. The property management agreement makes the owner aware what his responsibilities are. And that also lets him know that if the tenant doesn't pay, it's still ultimately going to be his responsibility to take care of those utilities.
Okay.
It acts as a disclosure to the owner.
Correct.
Again, that transparency.
Yeah.
I'm seeing a trend here.
Yep.
It's true.
We also updated animals, and this is for service emotional support, also the same.
This just basically notifies the owner that regardless of their preference, we have to follow the law. And if a tenant has a service or emotional support animal, we have to allow them to be able to have that. That also goes, a lot of HOAs will say no pets. They can't do that with emotional support animals. So it's the same disclosure to them that even though they have a preference, they can't.
Okay.
When it comes to those animals.
Section 20 that was added here is for religious and cultural display rights. This notifies the owner, the tenant has the right to display religious or cultural items. And if there are any types of repairs or work that need to be done on the property that requires removing these, that the tenant is required to get 72-hour notice prior to removing the items, unless it's an emergency. And it also compels the owner that if they do remove items, that they have to be treated
Respectfully.
without damaging them.
Right.
Yeah. And then returned after the work is completed.
So if something needs to be done on the property and this item is in the way and needs to be removed, and then...
Yeah, like a good example would be something on a doorway, for instance, and
Okay.
you have to repaint the doors.
Okay.
Say, okay, you have to give them notice, remove the item, go ahead, paint the doors, and then once it's dry, put them back up again the way they were.
Okay.
Okay, that's like an easy explanation, wouldn't you say, Ned? Yeah.
So notices, additional owners added.
This was a great move because it created space on page 1.
Right?
Right. So,
We basically moved it from page 1 back to here.
yeah.
And do you want to explain why we did that, Ned?
Well, we did that not only for room, but also because there might be more than one owner that requires notice. So there's a little room on here.
More than one owner?
If you notice, the same thing was done on the lease as well. So,
Correct.
So we did the same thing on this property management agreement.
The assumption originally was, like, say we have a lot of LLCs or a trust or something
just
like
one
that.
name.
It's usually one person needs to sign. But in a lot of our situations, we have a lot of mom and pops, right? So you have a husband and wife that are owners of the property. Well, in the past, we were just notifying one of them by the contract, when in reality, we needed to notify both of them because they were on title. So we just made that correction. So we have that extra owner, and there's actually some extra room that if we needed to place another owner in there, we could actually do that. Okay.
And then you also added a separate owner signature line
Yes.
to comply with that.
Well, we did that on the exhibit as well to do the same thing, right?
Okay.
Because before there was only one signature on the exhibit in the past. And then we added that. In addition, in the original property management agreement, it was saying that the exhibit was 1, 2, 3, where in actuality it was ABC. So we made that little correction there. And we left it open in the back. So instead of it just sitting as Exhibit A, and then you'd have to keep changing it if there was multiple properties, we left it blank. And that really is all the changes. There were quite a bit, but they're all pretty much law with the exception of the purchase agreement that we made modifications to that.
Touched a lot of documents, a little bit, each one of them.
Correct.
Yeah.
So we've been getting some questions on, do we have to redo our contracts that are already in place? And the consensus is that they only need to be renewed on renewals, right? That they need to be changed. If you can do an addendum to cover just the total fixed periodic rents, that works. It just depends on each brokerage on how you want to handle it. But the laws apply regardless of whether the new forms are used or not. Okay.
Well, thank you.
Very good.
All right. Hopefully we've answered all of your questions. Thank you very much for your time.
That's a wrap.
And that's a wrap.